This is the Retirement Key Podcast with Ryan Oliver, certified financial planner of Abish Financial Services.
Welcome back to the Retirement Key. My name is Casey, and I am here with Ryan Oliver, a certified financial planner with Abish Financial Services. And we are here to help you gain clarity and confidence about your retirement decisions. Ryan, great to see you. How are we doing today?
Great to see you, Casey. Good. I appreciate it. Thank you.
Yeah, well, I'm super excited to talk to you and have you here to get your thoughts today. Quick reminder before we get into it, though, as you are listening, if you'd like to learn more or schedule a complimentary consultation with Ryan, you can always visit us at theretirementkey.com. That is theretirementkey.com, and it has got all the resources that you need to get connected with us. Now, Ryan, what you and I are going to chat about today is something that every retiree needs to understand, and that's estate planning and the essentials that go along with that, making sure your wishes are honored, your loved ones are protected, and that your legacy is really handled the way that you want it to be. And it's a subject that not a lot of people like to talk about, but it's so, so important. So I'm excited to talk through it with you today. And I want to begin at the foundation. Many people think that estate planning is just write your will and you're finished. And so I want you to tell us why it's actually much more than that, and what core documents should every retiree have in place and know where they are and get that in order as they're planning their estate.
Yeah, Casey, that's a good question. And to be honest with you, that's why a lot of people who come in and see me, like even when we're doing these reviews, you know, when I ask that question, hey, how long ago did you complete your estate plan? Most of the time it's one person looking at the other, if it's a couple, and saying, hey, you know, I think it was that person over in this town and they were tall. And I remember they gave us a big binder and we were done. No, you're right. It's one of the most common pitfalls that we see all the time, and it seems relatively simple, but having a financial advisor that's looking at, you know, not only your investment profile, but also making sure all of those things aligns is really important. I mean, let's face it, like you said, these conversations aren't fun. They're not thrilling to have, and you don't want to revisit them all the time. But it's absolutely necessary to do more than just write a will. There's several core estate documents that you want to have in place, because your estate plan is not just, you know, what happens if you were to pass away. It's also what happens if you can't make decisions on your own, or, you know, who is it that steps in and fills that role for you? You know, what happens if you need to go to the hospital and you have certain wishes that you want to make sure happen? Those things change over time and it'll get stale. So you want to make sure that you have a standing healthcare proxy or a power of attorney, an advanced medical directive, including a living will that deals with the hospital topic I was talking about, financial power of attorney, up-to-date beneficiaries that reflect those wishes. And then, you know, obviously the will or the trust, depending on the complexity of your situation. But we recommend all the time looking at that, you know, every 3 to 5 years. Doesn't necessarily mean you have to revisit the conversation in totality, but just making sure those wishes are still applicable.
Yeah, and I mean, the will is very important, of course, but it is just one piece of a much bigger puzzle. There's all those documents that are important that you mentioned that are crucial to get in order before somebody passes away. So I want to build on that a little bit and talk about something that often surprises people. You mentioned having your beneficiaries up to date. I think a lot of people do not realize that beneficiary designations on retirement accounts or insurance policies can actually override what a will says. So I'm wondering if you can kind of break down how that works for us and tell us what people need to be reviewing, what they need to be updating on a regular basis.
Yeah, you're exactly right. And that always gets missed. I mean, that's one of, honestly, some of the most consequential financial mistakes that we see. Beneficiary designations are the most powerful estate planning tool, and it has nothing to do with seeing an attorney or you know, having any documents drafted, because they do, as you pointed out, take legal precedence over the will or the trust. So not going back and updating those, you know, those beneficiary designations, or at least making sure that the beneficiary designations that you have in place comport with the overall plan that you've put together with the estate planning attorney, can just throw the biggest monkey wrench ever into a really well-crafted estate plan. So it's just another reason why, you know, if you're self-managing or working yourself, you can kind of have, you know, quality control over this. But if you have a financial advisor, just make sure that they're asking you those questions and making sure that, you know, if the estate plan's done, okay, you know, what were the attorney's recommended beneficiary designations that align with what they did for you and what they put together, because at times beneficiary designations can be a component of the estate plan for tax reasons or just overall strategy. So yeah, definitely a key thing to understand is that, beneficiary designations are not, you have to address that even if you've already done the will and the trust. It's typically just a quick form and we help our clients with that, and you could probably get it from your custodian as well.
It's so important to remember those are legally binding no matter what's written in the will. And I feel like so many people forget to update those after a major life event happens, which brings us to one of the most common estate planning tools. I want to talk Trust 101 with you, Ryan. This can be a little confusing for people. So could you kind of walk us through the main types of trust? We've got revocable, irrevocable, testamentary, just to help listeners understand who might genuinely need each kind, because they're different, but they all kind of sound the same and it's very confusing.
Yeah, absolutely. So like to take that first step, like the will is, the most basic, financial plan that you can put together. But then for a lot of people, it can make sense to put together a trust. And you're right, they can be pretty confusing. I mean, you have revocable living trusts, which to be honest are the most common. Revocable living trust is what you'll see most commonly. You also have irrevocable trusts and testamentary trusts, all different kind of labels, but they serve similar purposes. Obviously there's different mechanics. Really what a trust provides you is, number one, privacy for you and your estate. While a will and assets that pass via a will are public record, the trust provides privacy. And that's true for all of the trusts, not necessarily testamentary, because a testamentary trust is formed by a will, so it doesn't actually exist until, your date of passing. But for the revocable and irrevocable trusts, which again are the most common, those two, they allow you to pass assets to your beneficiaries without having that be public record. And it also avoids probate, whereas a will does not. But the key to remember is, and why I mentioned that they're most common, a revocable living trust is essentially just a wrapper that you put around a non-retirement account. So keep in mind, you can't title a IRA or a 401k plan if you have those pre-tax accounts into a trust. You can only title those non-retirement accounts into that, or properties and bank accounts, other things like that. But a revocable living trust just allows you to put a wrapper around it and specifically spell out what you'd like to see happen with your money if you were to pass away, or what kind of continuity of planning there should be. This person should step in to make decisions. These are my named beneficiaries. You can even get ultra specific and say, I'd like this percentage to go to this charity, and then, from this specific account. And then after that, it's distributed to these. So it's just a whole laundry list, very heavily customizable. But with a revocable trust, you retain control of the assets, meaning it's part of your estate. If you ever decided, hey, you need to revisit this, you want to update it, you can do that legally, no problem. Whereas an irrevocable trust, you have to be careful with, because it tends to be used as a part of a more complex estate plan for people that are doing tax planning, whether that be for Medicaid or, to pass money, to their beneficiaries tax-free to pay for estate tax exposure. An irrevocable trust is exactly what it sounds like. Once you make those gifts to the irrevocable trusts, you are by definition removing that from your estate, which will also provide limited access to those funds. So that's a much more complex topic. Again, most of the people that are within reach and listening here, they're evaluating revocable living trusts versus wills. But we can look at, and talk about all those different types if, we want to make it more personal.
I think it's important to remember, too, that trusts are also not just a tool for the ultra wealthy, right? Everybody can use these.
Absolutely. Yeah. And that's a great point. And, it's a misconception. Most of the time, the language that you hear around trust-based planning is, well, that doesn't really apply to me because, that applies to, like you said, the ultra wealthy. But in reality, trust-based planning can be even more important for people who aren't necessarily ultra wealthy, but have dynamics in their family that they want, to make sure are well taken care of. And for example, this is just joking. I'm sure this applies to no one, but there's plenty of family situations, blended families. Not everybody likes their son or daughter-in-law,
right?
And so having that trust-based plan allows you to not commingle like your assets with people that you don't intend to. And you just can open a whole box of different things that you can take care of with that.
Yeah, they're practical tools that can give you control, privacy, protection, depending on whatever your situation is. Now, Ryan, I want to talk about the Secure Act for a moment because it changed a lot about how inherited IRAs work. So Could you walk our listeners through what is different now and how those changes impact strategy when it comes to planning your estate?
Yeah. So the Secure Act, there were a lot of changes that came about, but one of the most popular and most well-cited cases, especially if people are on social media, that you're going to be hearing about is the elimination of the stretch IRA. And this applies specifically when you're doing planning for a non-spousal beneficiary. So let's just say my spouse and I are doing planning for my son, Lucas. If something were to happen to my spouse and then, I leave money to Lucas, since he's a non-spousal beneficiary, he has 10 years from the date that I passed away to deplete that account. It used to be, before the Secure Act, that he could stretch those distributions out over the course of his lifetime based upon a required minimum distribution factor issued by the IRS. Well, and as the government gives and it takes away, as they pushed back the required minimum distribution age from, 70 and a half to 73 and then eventually to 75, they also have adjusted the stretch IRA rule so that more money is accelerated and comes out of those IRAs over that 10-year period if you pass away and leave the money to a non-spousal beneficiary. So it's an important thing to keep in mind. There's several different strategies that you can think about related to that. One is just understanding the different account types that you have and knowing what type of account makes the most sense to leave to what type of beneficiary. So some people that are charitably inclined choose to direct pre-tax IRAs to charities instead of to the beneficiaries that they want to take care of, because that's just the most tax efficient way to do it. There's also, proactive steps that you can take that, you could do a whole podcast on, such as, Roth conversions, getting money out of those pre-tax accounts into, those Roth IRAs, which have that same 10-year rule, but they won't, be taxable income to your kids. Now, that's not right for everyone. There's pros and cons. But there's a bunch of different strategies that you can kind of stem off and think about. But that's the core one, is that, the IRS now has accelerated distributions from those accounts.
Yeah. Well, it's so important just to know that it exists, because so many people don't. And it's something you need to think about now before you pass away, because you could be putting your loved ones in a huge tax mess down the road. Nobody wants to do that. So you've got to consider all the what ifs here. Now, let's shift to something, Ryan, that can leave a legacy and reduce taxes at the same time. Charitable giving can be both meaningful and strategic at the same time when it comes to estate planning. So can you talk to us about what role charitable giving can play in somebody's estate plan?
Yeah, absolutely. And unfortunately, I'll just get out ahead of it and say that kids aren't charity, although that's the most common question that I get related to it. I wish they were. But for someone who's charitably inclined, the door's open to a lot of different avenues that you can take, that make is a Roth conversion discussion right for me, or should I step my estate plan up even more personal and complicated in some ways. But there's a couple of different tools that you can use. One, you can use a tool like a donor advised fund, as a component of your estate plan. That's just essentially an account type that you can open and establish and contribute the optimally non-retirement, highly appreciated assets, meaning that Apple stock that you purchased, for $100 and it's now worth, whatever it is, 50,000. That's the perfect type of asset to donate. You can move money like the Apple stock without selling it into this donor advised fund, receive the full upfront tax benefit of the charitable deduction, then sell the Apple without paying tax on the gain and reallocate so that you can diversify the position, and then also create kind of a mini, less expensive foundation that you can use and make gifts from ongoing, and you can name beneficiaries of that account who then continue to make those ongoing distributions to charities. So that's one tool. Qualified charitable distributions are another big one for those clients or prospective clients that have reached age 70 and a half. We're often having this conversation. So qualified charitable distributions are essentially just you stroking a check directly from your pre-tax retirement account to a 501c3 organization. It's a great tool to use if you're already making gifts. Some of the most common are maybe to churches or to schools, to the alma mater. Once you reach age 70 and a half, it almost never makes sense to make those gifts out of your checking account. There's always different, more tax efficient avenues. ratios that can comport with a estate plan, a well-drafted estate plan. So, when you strike those checks directly from the IRA and then send it to the 501c3 organization, that does two things. One, you never paid tax on those dollars. You got the deduction when the money went in, and you never pay tax when it comes out, and neither does the charity. So it's a great benefit from a tax standpoint there. But then on top of that, once you're subject to required minimum distributions later at 73 or 75, those qualified charitable distributions, meaning those dollars you're giving to the 501c3 organizations, reduce that RMD dollar for dollar. So if you had to take out $10,000 over the course of a year and you make a gift of $2,000 to your church via a qualified charitable distribution, you're only taxed on $8,000, and your required minimum distribution is fully satisfied.
All right. So many tools to know about in this department, and it really just emphasizes the importance of working with a professional to help you create those tax efficiencies that you're looking for when you're planning your estate. Now, before we go, estate plans, Ryan, much like your retirement plan, are not a set it and forget it situation. You kind of talked about it a little bit at the top of the episode, but life changes, things happen. You've got marriages, divorce, loss of a spouse. All these scenarios can dramatically affect somebody's estate plan. So what updates should our listeners make immediately after a major life event? What do we need to be thinking about during this time?
Yeah, the first thing that I look at is beneficiary designations. Do those need to be changed? I mean, I can't tell you the number of times, and thankfully I haven't had it come up where it was an issue. We were able to address it on the forefront, but the number of times that I see someone in a second marriage or someone who is recently divorced and they have their ex-spouse named as the beneficiary of
get
those
dramatic.
accounts, it can get really sloppy, and there's no leg to stand on legally if that happens. If something, I mean, that's where the money is going. That beneficiary designation is the primary tool. So I'd say that's what you check on first. And then it's all these other ancillary documents. Like you said, Casey, life changes, things happen, kids are married, you move on throughout life. Some people pass away. Some people are, closer to you at some points and not as close later. Revisiting, it's a good process to revisit these documents every 3 to 5 years. Again, it doesn't have to be a dramatic, all in, revisit, but at least having them refreshed, specifically the key documents, like I said, those powers of attorney, the advanced medical directives, make sure those wishes still align. And just, what you can really do for yourself is either set yourself a note every 3 to 5 years, or just make sure that ask an advisor that you're working with to prompt you periodically to make sure that those things are still applicable, because, that type of planning, it adds a lot of value over time.
It's amazing how even one overlooked update can cause such big problems for families later on down the road, which is what we absolutely do not want to happen. Estate planning is just so important. So I want to thank you, Ryan, for sharing your insight on it with us today. And I wanted to ask, if our conversation struck a chord for anybody, how can they get in touch with you if they're ready to start their estate conversation? What should they do if they'd like to schedule some time to talk with you? Yeah,
head on over to the retirementkey.com. You can use, the resources there to book a complimentary consultation with us. We take a look at this as well as all aspects of your situation. The common thread is that, all of these things impact one another and everything's interrelated. So, in addition to the estate plan, we can look at other aspects to make sure that everything is working as efficiently as it can be.
There are a lot of pieces to this puzzle. So that is theretirementkey.com to learn more and schedule your complimentary consultation. Thanks so much for joining us as we broke down estate planning essentials for you today. We've got more great topics coming your way every single week. So make sure you subscribe wherever you get your favorite podcasts so you never miss an episode. And we will see you next time. Thanks, Ryan.
Thank you.
Thanks for listening to the Retirement Key Podcast. To learn more about Abish Financial Services, visit theretirementkey.com. Abish Financial Wealth Management is a registered investment advisor with the SEC. Registration as an investment advisor does not imply a certain level of skill or training, and the content of this communication has not been approved or verified by the United States Securities and Exchange Commission or by any state securities authority. The information contained in this material is intended to provide general information about Abish Financial Wealth Management and its services. It is not intended to offer investment advice. Investment advice will only be given after a client engages our services by executing the appropriate investment services agreement. Information regarding investment products and services are provided solely to read about our investment philosophy and our strategies.